Okay guys, let's get started. My name is Ajoy. Welcome to today's SCO live update. Today was day 6 in the plea for marriage equality for LGBTQIA plus persons. Solicitor General Tushar Mehta continued to argue against the petition for the union government. He began his arguments on a curious note. He argued that if sexual orientation and choosing one's partner was a matter of choice, and if the Supreme Court recognized this choice as a legitimate relationship in the form of marriage, what would stop future petitioners from seeking legal recognition for incestuous relationships? At this point, both Chief Justice Chandrachud and Justice Bhatt, the argument didn't sit quite well with them. Chief Justice Chandrachud said that sexual orientation first, he pointed out that sexual orientation, according to many scholars, isn't necessarily a choice. It's something that's immutable and that is carried by a person from the moment of their birth. And it's not a changeable aspect of a person. He also pointed out that the argument that recognizing same-sex marriage could lead to a legal recognition of incestuous relationships was far-fetched. But piled on there, he agreed and repeated the far-fetched comment, and he also pointed out that the state must have a legitimate interest before regulating some kinds of personal relationships, and that they would need to prove, and implying that this did not necessarily live up to that standard. The Solicitor General then listed a series of provisions in the Special Marriage Act that show that the statute is intrinsically inherently tied to the concept of heterosexual relationships. The provisions that deal with divorce, alimony, execution of decrees, that describe what a full-blood and half-blood relationship is, that set down the marriageable age. All of these provisions the language of all of these provisions imply that Parliament only had heterosexual couples in mind when they were like creating these relationships. The language is often stuff like pointing out men and women in their specific marriageable ages, or the fact that men aren't entitled to alimony under the Special Marriage Act. And he pointed these out to talk about how, in the process of trying to fit these provisions towards LGBTQIA couples, the Supreme Court would essentially have to reinterpret or rewrite certain parts of the Special Marriage Act, which was outside of that ambit. It would also create a separate class altogether within the same act. It would imply that there is, according to him, it would create one class of people who belong to the LGBTQIA plus community and another class who belong to the heterosexual community. And because of the differences in the act, it would require treating those two classes differently. And that's not, according to him, there was no intelligible differentiator to justify why you should treat those two classes differently. He also argued that even as the court decided on day one, even if the court decided to restrict this challenge to the Special Marriage Act and didn't delve into the waters of other personal laws, they wouldn't be able to ignore personal laws at any point. Personal laws will always seep into any interpretation of the Special Marriage Act because some of its provisions make direct references to other personal laws. For example, Article 19 to 21, which talks about succession for couples that got married under the Special Marriage Act. It essentially states that interfaith marriages will be governed by the Indian Succession Act, a more secular law that governs succession. But marriages between two people who are from the Hindu, Sikh, Buddhist, and Jain community will still be governed by the Hindu Marriage Act. This This is a relatively new provision, Section 21A. It was introduced, according to Mr. Mehta, as because the original Section 19, which restricted it solely to the Indian Succession Act, was acting as a deterrent against people from the Hindu, Sikh, Buddhist, and Jain communities from getting married under the Special Marriage Act. And because of these differences, because necessarily adjusting the succession provisions in the Special Marriage Act would have an effect on the Hindu Marriage Act, the SC could not provide a workable solution if they were restricting themselves in this case. So CJ Chandrachud at this point summed up the arguments made by Mr. Mehta. He said, according to him, Mr. Mehta's arguments were: one, that reinterpreting the Special Marriage Act would involve substantially rewriting the statute, essentially. Two, that the Supreme Court would have to ignore the language and apply certain provisions from the Act in a different way by ignoring said language. And lastly, that in order to recognize marriage equality, the Supreme Court would necessarily have to delve into other personal laws, which they stated in the beginning of the case that they were not going to do. He also listed a number of other statutes under the Special Marriage Act, which are intrinsically tied to the concept of heterosexual marriage. He then responded to Senior Advocate A.M. Singhvi's argument from last week, talking about a UK case titled called Ghaidan. In this case, Dr. Singhvi argued that the court could, using principles adopted in this case, he argued that the Supreme Court could interpret the Special Marriage Act such that it fell in line with the Constitution, and thus, in order to give effect to the right to equality under the Constitution, the Supreme Court could interpret the Special Marriage Act to include marriage equality. Solicitor General Tushar Mehta also relied on Ghaidan in his arguments as indirect response to Singhvi's arguments. While Dr. Singhvi relied on Baroness Hale's opinion, Mr. Mehta relied on the opinion of Lord Nichols, who said that the interpretation of the statute could not be contrary to the intent or tamper with the architecture of said statute. He also argued that the case in Ghaidan was only dealing with the rent enactment, and that the Supreme Court's ambit here was regarding the recognition or the creation of a social institution by recognizing marriage equality. He also spoke about the differing approaches to interpretation between the UK courts and the Indian courts. Whereas in Indian courts, because of the wide expanse of powers the Constitution affords the Supreme Court, the Supreme Court will often take a slightly narrower view and read down a statute and reduce the scope of effect that a statute might have. Whereas in the UK courts, there is a concept of reading in a statute, reading in a meaning into a statute that did not previously exist or was not previously known. And this expands the application of a statute. Reading in a statute is not something that is well recognized in Indian law, and so the Solicitor General pointed that out. And he said that it's all, like the Supreme Court has seen it as illegitimate in past cases. And what was being asked by the petitioners was essentially reading in marriage equality into the Special Marriage Act, which, since the Supreme Court has rejected on the past occasion, would not be a legitimate option to pursue right now. The bench also recognized the difficulty they faced. With stepping on the toes of the legislature and entering the legislative realm, as Mr. Mehta has been warning them and cautioning them for the last 2 days. But alongside that, Chief Justice Chandrachud also pointed out that now this right to cohabit, not just the right to marriage, but the right to cohabit with another person is a fundamental right, as an intimate relationship. And if that is recognized, ever since 377 it was read down, it has been recognized. He pointed out that the state has a duty to recognize all of the social incidents that surround or revolve around this cohabitation. and that these incidents such as having a joint bank account, getting tax benefits, adoption, and other benefits that heterosexual married couples have had, and that integrating these benefits into queer relationships is something that's extremely important that the state has an obligation to realize. The bench asked Mr. Mehta if he could return on Wednesday after a discussion with various ministries from the union government and find out what steps could be taken to protect queer relationships and bring them on a level playing field, even if the status of the legal recognition of marriage isn't granted to them, to give them the rights accorded to heterosexual couples. Mr. Mehta agreed to this point. He pointed out that it wasn't the scope of this case, but he said that the union was in no way averse to this, and as a welfare state, he seemed to agree that this duty fell upon them, but he didn't elaborate as such. But he did highlight that the decriminalization of same-sex relationships back in Navtej Johar, the union interpreted that and did not understand that to give same-sex relationships or queer relationships any sort of status. They saw it solely as the Supreme Court decriminalizing these kinds of relationships. Justice Call, appearing online, disagreed with this notion. He said that with decriminalization, there was an indirect admission that such a status could prevail, that these relationships existed, and that social ministries following this case would presumably have done some analysis and done some research and looked into the idea of what these relationships could look like and what protections they might need. And he also highlighted that this aversion towards queer relationships is a holdover primarily from Victorian philosophy that was transported and imposed during the British Raj. And it wasn't a part of our own civilizational philosophy. This sparked a larger discussion from the bench, speaking about depictions in many temples that seem to depict and celebrate queer relationships, and spoke about how we used to have, and in a lot of ways still have, a culture of inclusivity. But this culture of inclusivity was transposed by Victorian morality when the British Raj came. On Wednesday, Solicitor General Tushar Mehta will return with this note from various ministries on what protections they think they could provide for queer couples, and the arguments for the union side, or rather the arguments for the respondent side, will continue. So, Additional Solicitor General Aishwarya Bhati will come and represent the National Commission for the Protection of Child Rights. Rakesh Trivedi will appear, Senior Advocate Rakesh Trivedi will appear and represent the state of Madhya Pradesh. And by Wednesday or Thursday, they should be wrapping up respondent arguments. That's it for today's SCO Live update. Thank you for joining us.